Good evening, everyone, and welcome to our today's session. And we'll be discussing a very important topic today in UK's landscape, and that will be a family law matter. And we have got Mr. Farooq, Khondakaramu Farooq, based and solicitor, Avista Solicitors. Mr. Farooq, welcome to today's session.
Thank you very much, Jaidev, for inviting me.
So, yes, as we have discussed, we'll be discussing the issue of divorce in British law and as well as the clean break order we usually hear about divorce as well. So yes, if you can just give a basic idea about the divorce proceedings first, what it is and why people go for it.
Thank you very much for asking this question. Basically, divorce is not expected, but there could be some situation where this is the only option. And in England and Wales, since middle of 2022, there has been no fault divorce, which means either party can apply to the court
Hmm.
or individually or jointly, and at the end, divorce will take place.
Hmm.
So the first step is to make an application to the court, and um, it can be done by both parties jointly or any party alone.
All right. So that is the basic thing. Okay, so when people think about, so what's your take on
Well,
that?
a straightforward divorce can take around 6 to 8 months because once you apply to the once you make the application,
Hmm.
it obviously gets checked by the court staff, and within a week or two it gets issued, and then the acknowledgement service goes to the other side, the respondent,
Hmm.
and if he or she does respond timely, and then you have to have a holding period of 20 weeks. And
Hmm.
then once the holding period is over, the applicant can apply for conditional order. We used to be called decree, it's called conditional order now. Once you apply for the conditional order, that takes about 3 to 6 weeks to get approved. And so once
Hmm.
this conditional order is pronounced, granted, and then after 6 weeks and a day, which is 43 days, you can apply for final order, which used to be called decree absolute. So that's the end of it.
All right. So you have said one thing that if the other party responds in timely manner, what if they don't respond?
Well, basically, the other party cannot stop it because it's no fault divorce. Whether
Hmm.
there is fault or not, it doesn't matter. So if the other party doesn't respond on time, it could be a bit delay, but at the end, it will take place.
All right. So another thing I want to touch a bit as well. You said no fault. That means there is also another ground of fault-based divorce. Can you touch that as well, if you can?
So basically, you don't have to show any fault. In the old days,
Hmm.
so many conditions and so many people got stuck with divorce petition. Like if you can remember, we had one divorce since 2019, and then it got finalized in 2025. Then one got in 2021 that got finalized 2 weeks ago, because
Hmm.
those are old divorce cases. But
Yeah.
you had to prove like both parties live separately or there's fault and blah blah blah. Um, so basically, you don't have to show any fault.
Okay. So when it comes to divorce, if it is like only for the uh, spouses, then it's a different thing. But when there are children and financial matters involved, this is quite complex. So how do you deal with that when it's
Well,
when
when
the
the other party receives acknowledgement of the service, there is one option whether you
Mhm.
want to make a financial application. And the same with the applicant's application, there is a section called whether you want to apply for financial remedy. So if the spouse, the applicants or the respondent ticks it, then obviously then they have to issue Form A, which is notice for financial remedy application. That's a separate procedure. But
Mm-hmm.
just taking financial remedy application is not enough. You have to apply for it. So normally, what is the external procedure? Like you get conditional order, and by this time you agreed about your finances and assets and liabilities, future financial responsibilities, and then it is submitted along with the a court, and the court says whether it's a fair and reasonable agreement. Then the court approves. If it is contested, then obviously it takes time. Unless or until it is sorted, the court will not pronounce final order.
Okay. So yeah, that seems to be quite complex.
Very complex. So the starting point is like when there is a divorce, people should have a clean break agreement regarding their finances and children,
Mm-hmm.
blah, blah. But if there is none, and even after the divorce, years later, any party can apply for financial remedy.
All right. So what if someone does not want to do the financial remedy? What's the impact in future?
Um, is the parties are always at risk of financial remedy application or litigation.
Mm-hmm.
Say, for example, um, you probably not very well off now. 5 years down the line, you say, for example, you win lottery, and the other
Mm-hmm.
party could come up and say, "Hang on, I have a bite on that," and legally you can't stop that. So if you have a clean break agreement, whether it's consented or contested, we
Mm-hmm.
always advise get it done. Even if it is consented, it has to be approved by the court, because the court will
Okay.
want to see whether both parties are on the same or equal footing. Like you live in a mansion and your other party cannot be on the street. It has to be
Mm-hmm.
shown that both parties' housing needs are met, future income capacity, and whether there are children, what would be the children's arrangement, etc.
Okay. So when you say clean break order, that means clean break in actual meaning.
Clean break means from that point, you have your own financial assets, and you will have control. Your other party, your other ex-spouse will have no say to it.
Mm-hmm.
Normally, clean break will involve your assets, your finances, your debts, liabilities, pensions, shares, everything it will include.
Okay. I mean, it's just a question coming to my mind that, I mean, when you're talking about clean break, you mean everything stops from that point. What if there are children who needs ongoing support?
Again, in that clean break, there should be mentioned everything like who pays what.
Mm-hmm.
If there are children, obviously there will be provision in the clean break agreement. Otherwise, it will not be approved by the court, whether you agree or not. There is a common myth, very that divorce finished and everything finished. No, especially if there are children, there have
Mm-hmm.
to be a provision for the children. At least for um, like until they finish the university, if they are in full-time education, and what would be
Mm-hmm.
who pays what, and if you have a pension, like and it could be divided between the parties as well. So basically, the court will want to see that both parties are on the equal footing. Obviously, lots of things will be taken into account, like the duration of the marriage, contribution of the parties, future earning capacities, age, and their assets and liabilities. Everything will be
Mm-hmm.
considered. But say, for example, like someone was asking me, like the marriage was short, and she lived only few months, and again, I have got like the applicant has got like few assets, and there's a antenatal or prenatal agreement which provides that she will be provided only £50 a month. This is preposterous and impossible, because In the UK, 50 pound, how can you live on 50 pounds? So obviously,
Yeah.
it
Mhm.
has to be reasonable. You can just you can't just present this prenuptial agreement before the court. I'll say, look, there is a prenuptial. No, the court will want to see that the other party also has a reasonable adjustment with her lifestyle, even though the marriage is short. It doesn't matter.
Okay. So one thing you have mentioned that those agreements have to be approved by the court. Does that mean that the parties cannot by themselves make that, or I mean, financial agreement?
Yes, of course, the party is always encouraged. Even if you go to court, even if it is contested, not consented, the
Hmm.
court will always encourage to agree between the parties, and then the court want to impose any order at the last resort, because
Hmm.
even if it is consented, which like you agree between the parties, you have to
Hmm.
produce before the court. The court will see whether it's reasonable. You just simply cannot agree. Maybe the other party is on a very vulnerable situation, and she probably or he probably will agree. But at the end of the day, the court is the final arbiter of whether it's reasonable or not.
All right. I get it. It seems quite complicated, this area of the,
It's very
I mean,
complicated,
family
very
law.
complicated. I always advise my clients, whoever comes, like they ask me, how much is gonna cost? I said, I cannot give you any estimate, because if it is consented, then I can give you a rough estimate. But if you contest it, it could be thousands and thousands of pounds. I don't know how many hearings there will be, and um, I don't know. Maybe we have to engage, the asset search. Sometime parties they hide asset,
Mhm.
they transfer asset and blah blah. They set up trust and stuff to hide asset and to deprive and deceive other parties. So I know no solicitor will be able to give you a estimate at the beginning if it is contested.
Yeah.
So
But
it's very complex.
we have seen clients who wants to deal by themselves to save some money. What's the advice on that?
Again, you um, agree is fine, and then obviously you get legal help, because if you agree and present it before the court, there is no guarantee that it will be approved, because as I mentioned time and again in this program, that the court wants to see whether this is a reasonable, because first thing will be whether both parties housing needs are met, you know as I said,
Hmm.
and then both parties, whether they are able to work, their age, maybe one party is incapable of working, maybe disability. So it has to be taken into account, everything.
So, because it's a quite complicated and sensitive area, when someone comes to you regarding a divorce and financial matter cases, how do you usually deal with that?
Well, first of all, I advise them to patch up if possible, because that's my legal and moral duty. And I
Hmm.
also advise them to use mediation, because especially in financial remedy cases, using mediation is a must unless there is domestic violence issue involved. So if you go to court without doing mediation and there is no domestic or other extraneous circumstances involved, then the court will ask to go back and do the mediation again. So I
Hmm.
encourage them to do the mediation, because the mediation certificate is a must in financial remedy application, and then obviously they can go to court.
All right. All right. Thank you so much. You have been, I mean, you have explained that such a beautiful way, and we really appreciate that. So, yes, viewers, if you have any questions regarding your family law issues, you can definitely contact Mr. Farooq in the given number of Avista Solicitors, and I believe he'll be more than happy to help you. So, any final words for our viewers, Mr. Farooq?
Final words is, don't divorce or don't get divorced. But as I said, there are some situations where you can't avoid it.
Mhm.
So do it not in a hostile way, amicable way. Don't fight, because it's gonna cost you money, stress, time. So if you really have to divorce, then come to an agreement with financial children with the other party. If you need help, we can guide you. Signpost. We are not the mediator; we are the solicitor, but we can also always signpost you, so that it
Mhm.
can be a bit less stressful and less expensive process for you.
All right. Thank you so much, Mr. Farooq, for joining us today. And thank you to our viewers as well who have been so beautiful with us. Thank
Thank
you
you
so
so
much.
much. Thank you. And I hope this session, whoever watching or will be watching, will get some feedback and will be helpful for them. Thank you so much. Have a good evening and have a good weekend. Thank you very much.
You too. Bye.